In April 2025, a significant legal confrontation unfolded in Washington, D.C., highlighting the ongoing tensions between the executive and judicial branches of the U.S. government. At the center of this dispute were Attorney General Pam Bondi and U.S. District Judge James Boasberg, whose conflicting views on the limits of executive power and judicial authority brought to light critical questions about the separation of powers enshrined in the Constitution. The controversy began when Judge Boasberg issued an oral order during hearings concerning the Trump administration's use of the Alien Enemies Act to deport migrants, primarily Venezuelans, to El Salvador. He directed that any planes carrying these individuals, whether about to take off or already in the air, be returned to the United States. Despite this directive, 2 planes continued their journey to El Salvador, prompting Judge Boasberg to find probable cause to hold the administration in criminal contempt for defying his order. Attorney General Bondi responded by filing an emergency appeal to the D.C. Circuit Court of Appeals, seeking a writ of mandamus to halt Judge Boasberg's contempt proceedings. She argued that compelling the executive branch to prosecute contempt charges infringed upon the president's exclusive prosecutorial powers, thus violating the separation of powers doctrine. The Department of Justice contended that the migrants in question were members of the Tren de Aragua gang, a designated terrorist organization, and that their deportation was a matter of national security. Bondi emphasized that Judge Boasberg's order effectively forced the executive branch to persuade or coerce a foreign sovereign, El Salvador, to comply with U.S. judicial demands, further complicating international relations. Missouri Independent. Judge Boasberg, undeterred, insisted that the administration identify the individuals responsible for not halting the deportations. He warned that if the government failed to initiate prosecution, he would appoint an independent attorney to pursue the contempt charges, citing the criminal contempt statutes that allow for such appointments when the interest of justice demands it. This legal standoff underscored the broader constitutional debate over the balance of power between the judiciary and the executive. Bondi's stance reflected the administration's view that the judiciary was overstepping its bounds, while Judge Boasberg maintained that the rule of law required adherence to court orders regardless of executive preferences. As the situation evolved, the Supreme Court intervened, ruling that the dispute over the Alien Enemies Act should be moved to Texas, where the migrants had filed their petitions. However, Judge Boasberg retained control over the contempt proceedings, further intensifying the legal battle. This confrontation between Attorney General Bondi and Judge Boasberg not only highlighted the complexities of immigration enforcement, but also raised fundamental questions about the separation of powers and the limits of judicial authority in matters of national security and foreign policy. As Judge Boasberg prepared to move forward with contempt proceedings, Attorney General Pam Bondi acted swiftly. She petitioned the D.C. Circuit Court of Appeals for an emergency writ of mandamus, a powerful and rare legal instrument used when a lower court is believed to have grossly overstepped its authority. The urgency of Bondi's filing signaled how seriously the Trump administration regarded Boasberg's actions. Bondi's argument was rooted in constitutional precedent. The power to prosecute or not prosecute criminal charges belongs solely to the executive branch under Article 2 of the U.S. Constitution. In other words, Bondi was asserting that no judge, regardless of the circumstances, could force the Department of Justice to pursue criminal contempt charges if it chose not to. In her scathing appeal, Bondi accused Judge Boasberg of attempting to compel the government to advance a non-existent criminal contempt case. She framed this as not only unconstitutional but also dangerously precedent-setting, claiming it would open the door for future judges to override executive discretion simply based on personal disagreement with administration policies. More specifically, Bondi's team argued, the executive branch had already decided not to pursue contempt charges because the deportations involved individuals classified as members of Tren de Aragua, a Venezuelan-origin criminal syndicate accused of terrorism. The Justice Department had reviewed the situation and concluded there was no prosecutable criminal contempt case. The migrants were removed under the Alien Enemies Act, which gives the president wartime powers to expel foreign nationals seen as a threat. Judge Boasberg's order, in their view, was not a clear and unequivocal directive necessary to sustain a contempt charge. Bondi's legal filing also emphasized the dangerous overreach in forcing executive agencies to take action against their own members. As she put it, it is an extraordinary thing for the judiciary to demand the executive prosecute itself. It's a legal fantasy. The appeal landed with significant weight. Legal scholars across the country weighed in, with conservative commentators lauding Bondi for standing up to judicial activism, while liberal voices criticized the administration for circumventing judicial oversight. As the writ was reviewed, the Trump administration went on a media offensive. Bondi appeared on national news shows asserting that Judge Boasberg's attempt to micromanage immigration enforcement violated the Constitution's separation of powers. In her words, this is not about immigration. It's about whether judges can act as prosecutors, and that's not how America works. Back in the courtroom, Judge Boasberg refused to be silenced. He doubled down, warning that if the Department of Justice would not file contempt charges, he would appoint a special prosecutor, an action reminiscent of historical showdowns like Watergate and the Russia investigations of the late 2010s. Boasberg referenced Federal Rule of Criminal Procedure 42, which allows a judge to appoint a private attorney to prosecute a contempt case if the government declines to act. He noted the judiciary is not a powerless bystander when its authority is openly defied. The rule of law must stand. This looming threat added fuel to the fire. The stage was now set for an unprecedented confrontation, a Trump-appointed attorney general accusing a federal judge of unconstitutional interference, while that very judge invoked a legal pathway to bypass the executive branch and pursue contempt charges independently. In the middle of all this was a group of Venezuelan nationals quietly detained or already deported pawns in a much bigger power struggle. With tensions escalating, all eyes turned toward the D.C. Circuit Court of Appeals. Would the judiciary back Boasberg's right to uphold court orders, or would it side with the Trump administration's stance on prosecutorial independence? As the legal clock ticked down, the implications were enormous, not just for immigration law, but for the future of checks and balances in America. With the nation watching and legal analysts furiously debating every move, Judge James Boasberg responded in full force. From the bench, he asserted not just the right, but the obligation of the judiciary to enforce its rulings, even if that meant pressing forward without the Justice Department's help. During a fiery courtroom session, Boasberg declared, "If the courts cannot uphold their own orders, then our entire system of justice is a fiction. The executive branch cannot be allowed to simply shrug off a directive and walk away without consequence." Boasberg maintained that the April 5th oral order he had given, to stop deportation flights and return any planes in transit, was clear, direct, and enforceable. He challenged the Department of Homeland Security and Department of Justice to explain why 2 flights had continued to El Salvador despite the injunction. The administration's attorneys replied that the order had not been issued in writing and thus was not legally binding at the moment the planes departed. They said logistical and communication issues had contributed to the confusion. But Boasberg wasn't buying it. In an unusually confrontational moment, the judge asked from the bench, "Are we to believe that in this age of instant communication, the government had no ability to relay a federal court order before those planes touched down?" This sharp rebuke echoed across the legal world. Constitutional scholars were quick to highlight the broader issue at stake. Whether an oral ruling from a federal judge carries the same weight as a written one. Though traditionally written orders are preferred, oral orders are not unprecedented, and can still be legally enforceable if properly entered into the record. Pam Bondi, meanwhile, continued to frame the judge's actions as a rogue maneuver. In a press conference, she slammed Boasberg's threat to appoint an outside prosecutor. "This is an unconstitutional end run around executive authority. The judge isn't enforcing the law, he's rewriting it." She further warned that allowing this to proceed would set a dangerous precedent where federal judges could bypass the Department of Justice anytime they disagreed with administration policy. But Boasberg seemed undeterred. He made moves to invoke Rule 42B of the Federal Rules of Criminal Procedure, preparing the groundwork for a court-appointed special prosecutor. According to legal experts, this rule gives a federal judge the authority to appoint a private attorney to prosecute criminal contempt if the government refuses to act, a rarely used but entirely legal option. That possibility sent shockwaves through conservative circles. Right-leaning media outlets called it a judicial coup, while others warned of a constitutional crisis in real time. But progressive legal minds praised Boasberg for standing up to what they saw as executive lawlessness. At this point, another legal twist emerged. The D.C. Circuit Court began hearings on Bondi's emergency petition for mandamus. During the initial oral arguments, several of the appellate judges appeared skeptical of Bondi's claim that Boasberg was acting unconstitutionally. One judge asked, "If a federal court cannot ensure its orders are respected, what remedy is available?" Bondi's response was firm: the remedy is political. If an administration breaks the law, Congress and voters are the accountability mechanisms, not a judge with a self-appointed prosecutor. Still, the court's line of questioning suggested that at least some of the judges were open to Boasberg's interpretation of Rule 42b. And while a final decision was still weeks away, the momentum appeared to be shifting. Meanwhile, the political ramifications were escalating. Democrats accused the Trump administration of obstructing justice. Republicans claimed Judge Boasberg was engaging in judicial tyranny. The media lit up with op-eds, panel discussions, and legal breakdowns. But amidst the legal firestorm, one thing became clear: this was no longer just about deportation flights. This was about the fundamental power dynamics between co-equal branches of government and which would emerge stronger. As the courtroom battle escalated, the United States found itself at a rare constitutional crossroads. In Washington, D.C., the debate wasn't just about contempt charges or immigration anymore, it was about the limits of judicial power versus the immunity of executive decision-making. Pam Bondi doubled down, giving interviews on Fox News, Newsmax, and other conservative outlets. Her message was sharp and unwavering. This is about more than just President Trump or a single court order. This is about defending the constitutional boundaries of power. Judges can't prosecute. That's the DOJ's job, and the DOJ already said there's nothing to prosecute. Her office released a detailed 20-page legal brief highlighting historical precedents going back to the Youngstown Sheet and Tube Company v. Sawyer case from 1952. In that landmark decision, the Supreme Court had limited the president's ability to seize private property without congressional authorization even in a time of national emergency. Bondi's team argued that, just as the executive must obey Congress, the judiciary must respect the prosecutorial discretion of the executive. But Bondi wasn't just citing history, she was accusing Judge Boasberg of trying to reframe criminal contempt as a judicial tool outside the ordinary process of federal prosecution. Her legal team's argument went even further, stating, "This is not about enforcing court orders. It's about forcibly creating a criminal defendant when the prosecutor refuses to act. That is not how American justice works." Meanwhile, Judge Boasberg wasn't backing down. He held another courtroom session and made it clear that he believed the executive branch had deliberately flouted a court order, and if no one was going to be held accountable, then the judiciary itself had to act to preserve its integrity. We are not talking about abstract authority here. We are talking about the enforcement of the rule of law in real time. He emphasized that the oral order he issued was official and binding and that the administration had made no effort to halt the deportation flights after being made aware of it. According to court records, immigration enforcement officials had received the directive shortly before takeoff yet did not attempt to turn the planes around. That failure, Boasberg stated, was tantamount to defiance. With both sides dug in, the legal and political commentary intensified. MSNBC aired segments titled The Boasberg-Bondi Battle: Separation of Powers in Crisis. The Wall Street Journal published an op-ed praising Bondi's courage in the face of judicial overreach. Harvard law professors held live-streamed forums breaking down the constitutional implications of Rule 42b. Even former federal judges weighed in. Some argued that Boasberg had every right to enforce compliance, while others cautioned against setting a precedent where judges could effectively appoint their own prosecutors, transforming the judiciary into a quasi-enforcement body. Public opinion began to polarize. On the left, many saw Boasberg as a principled defender of judicial independence. On the right, Bondi was cast as a modern-day protector of the executive branch, standing up against what they called a weaponized judiciary. And in the middle of it all, the D.C. Circuit Court continued deliberations over the mandamus petition. Oral arguments had concluded and a decision was expected within weeks. Yet the tension on the ground was already having ripple effects. Other federal judges began issuing clarified written orders in real time to avoid similar challenges. Legal scholars noted an uptick in Rule 42 references in federal dockets, judges signaling that they were watching this case closely, ready to cite precedent. Meanwhile, immigration enforcement authorities, now under even more intense scrutiny, began pausing deportation proceedings in similar cases, fearful of violating new judicial orders. This was no longer just a legal dispute, it had become a flashpoint for how America governs itself. Boasberg was defending the dignity of the bench. Bondi was protecting the prerogatives of the presidency. And everyone, from legal students to elected officials, was waiting to see who would the Constitution side with this time. By mid-April 2025, America's political, legal, and media landscapes had narrowed in on one key question: would the judiciary really go through with prosecuting Trump administration officials without the Justice Department's support? The D.C. Circuit Court finally issued its ruling. In a 2-1 decision, the panel denied Pam Bondi's request for a writ of mandamus, affirming that Judge Boasberg had not overstepped his authority by preparing to appoint a special prosecutor under Rule 42b. Writing for the majority, Chief Judge Sri Srinivasan stated, "Where the executive branch declines prosecution for reasons that risk undermining the judiciary's ability to enforce its own orders, Rule 42b offers a lawful, if rarely exercised, remedy." In short, Boasberg was in the clear. This ruling triggered a political earthquake. Conservative lawmakers, already vocal about the case, launched immediate calls for congressional intervention. Florida Congressman Matt Gaetz introduced a resolution to censure Judge Boasberg, calling him a threat to constitutional order. Marjorie Taylor Greene dubbed it judicial tyranny, and former President Donald Trump himself issued a statement from Mar-a-Lago. "This is a total disgrace. A left-wing judge is hunting down patriots, and Joe Biden's DOJ is sitting back and smiling. It's a witch hunt." Meanwhile, on the left, the decision was hailed as a historic win for checks and balances. Rachel Maddow called it a landmark moment for judicial integrity, and Senator Elizabeth Warren said it proved that even the most powerful officials must obey the courts. But the ruling didn't end the crisis, it ignited the next phase. On April 18, Judge Boasberg formally appointed David Schertler, a prominent Washington-based criminal attorney and former federal prosecutor, to lead the contempt investigation. Schertler was known for his meticulous approach and nonpartisan record, having served under both Democratic and Republican administrations. His mandate: investigate and, if warranted, prosecute individuals responsible for violating the court's order regarding deportation flights. Within days, subpoenas were flying. Schertler requested communication logs from Immigration and Customs Enforcement, ICE, Homeland Security, and even internal DOJ memos that might have referenced the oral court order. He reportedly focused on whether acting ICE Director Tanya Jordan, a Trump appointee, gave the go-ahead for the flights even after being made aware of the ruling. Behind the scenes, Pam Bondi went into overdrive. Her team filed emergency appeals with the Supreme Court asking for an injunction to halt the appointment. But the court, still weighing whether to even hear the case, declined to issue an immediate stay. With the subpoenas mounting and the court's authority reaffirmed, a chilling message spread throughout Washington. The judges are watching. Bondi's strategy shifted. Realizing the legal avenues were closing, she pivoted toward public opinion. She launched the Constitutional Defense PAC, which began raising millions from conservative donors. Its mission: to fight lawfare and judicial extremism. Meanwhile, Boasberg continued presiding over unrelated cases as the nation watched his courtroom like a pressure cooker. He refused interviews and even rebuffed statements from legal groups defending him. "The court does not comment on pending matters" was his only line to the press. But that didn't stop the speculation. Cable news debated daily whether this new phase, judicially initiated prosecution of contempt, would become a trend. Legal scholars wrote dueling op-eds with titles like, "Boasberg's bold move could save the courts," "Goodbye separation of powers? The judiciary goes too far." In early May, Schertler's office announced it had completed its preliminary review and had identified 2 officials likely to face formal charges of criminal contempt. Pam Bondi, in a televised response, thundered, "This isn't law. It's vengeance. And the American people will see through it." Yet inside the legal world, Boasberg's position had been vindicated by the D.C. Circuit, by legal precedent, and increasingly by public sentiment. Polls conducted by Reuters Ipsos showed that 52% of Americans supported the court's right to appoint a special prosecutor if the DOJ declined to act. It was a narrow majority, but a majority nonetheless. Though no convictions had been made yet, this historic case was already reshaping legal norms. Federal judges across the country began issuing written orders alongside oral ones just to avoid ambiguity. Law schools added Rule 42b to their core constitutional law syllabi. And inside the Department of Justice, internal discussions emerged about creating guidelines for how to respond when courts seek independent prosecutions. Pam Bondi remained defiant, rising in stature among conservatives as a martyr for executive power. But Judge Boasberg, too, earned admiration from across the ideological spectrum for refusing to yield when court orders were ignored. In the end, this case wasn't about immigration flights alone. It became a referendum on accountability. A test of whether the law applies to everyone, especially those in power. And a warning that even in an age of partisan warfare, the American judiciary still has teeth.